Sí, pues buenos días de nuevo a todas y a todos.
Good morning, everyone. This is the second day of this doctoral seminar of the Carlos V European Award Angela Merkel, the fortune of being united, securing and strengthening Europe's cohesion. Today's topic is about mobility, and then we'll talk about asylum, migration, interconnected topics. So now we have Ignacio Fornaris Valls that will be introduced by Professor TERESA FREIXES SANJUÁN, the Jean Monnet full professor at personam and vice president of the Royal European Academy of Doctors, co-director of this course and member of the jury. Always a pleasure. You have the floor. Thank you for everything. Thank you for having me in this doctoral seminar. So interesting. I will only make a brief introduction of Dr. Fornaris because we're interested in listening to him and then the debate. Mr. Fornaris completed a double degree in law and business administration and management at Complutense University of Madrid. He subsequently worked as a lawyer, which is interesting from the point of view of this seminar. So he can also talk from a practical point of view. And then after several years of practice, he decided to redirect his career towards research and teaching. He's currently a pre-doctoral FBI researcher at the Royal Institute of European Studies at San Pablo University, but he's also developing his doctoral thesis under a joint supervision agreement with the University of Bologna, which gives it a special flavor. That is a very interesting experience, and he will be talking about something that is really at the heart of many debates in the European Union. He will be talking about asylum, which is relatively new in the treaties. It only appeared for the first time under the Treaty of Amsterdam, then in the Treaty of Lisbon and the Protocol 24 and the derived law induced by the treaties, because the right of asylum had been regulated by the legal frameworks of the states and the Convention of Geneva and the one governing the status of the refugees. And member states wanted one common asylum procedure, and he will be talking about the common procedure for asylum and the problems of the asylum and what to do when the asylum status is rejected. We will be talking about the safe third country concept, which is controversial, and it will cause some interesting interpretation problems that will influence what we are living and what will come, because every time there is a conflict, there is a new wave of immigrants and asylum seekers. So I will stop here and give the floor to Mr. Fornaris. Good morning, and thank you, members of the Academy of Yuste, for giving me this scholarship, Charles V. It's a real honor and a pleasure that I can that I can be part of this academic community with my fellow researchers and the interpreters because of these debates. In this framework, my intervention will be about the controversial concept called third safe country, safe third country, used in the international protection requests, in especially the case between the European Union and Turkey.
En los últimos años, la Unión Europea ha trabajado.
In recent years, the European Union has moved towards a common policy on protection, on asylum and subsidiary protection, with the aim of offering international protection to anyone needing it and to guarantee the effective principle of non-return. This is not returning anyone to a country where their physical or mental integrity is at risk. It is based on the Convention of Geneva, but has been developed through a very complex network influenced by the migration crisis and the will to reinforce solidarity between member states. In May 14th, 2024, 10 new legislative instruments were approved under the new Pact on Migration and Asylum, including the new regulation on asylum procedures, which will repeal Directive 2013/32 Asylum Procedures Directive. Today, I will focus on one of the two controversies that have arisen around the concept of safe third country, the designation of a country that does not de facto readmit non-nationals, and the collateral effect of the inadmissibility of such applications. Although the title did not limit the scope of the research, as I have worked upon it this month, I considered appropriate not to address the judgment of the Court of Justice of the European Union of October 4, 2024, the demarcation of safe areas within a single country, because I didn't have the time to. But in any case, it should be noted that the problem with the Italy-Albania agreement is known and will be also addressed by the next speaker. That said, it is undeniable that this is a concept of great public relevance. The European People's Party, at its recent Congress in Valencia, proposed using the mechanism as a key tool to reduce the number of asylum seekers admitted to the territory. This strategy is in line with the European Commission's intentions to reform the traditional criteria. Among the proposed changes is the elimination of the requirement of a personal connection with the third country, allowing mere transit to be considered sufficient, as well as the removal of the suspensive effect of the appeal when an applicant challenges the application of the concept of the third country, which affects the fundamental guarantees and the effective access to the protection within the European Union. In today's presentation, I will address the following points. First, I will give a brief overview of the Asylum Procedures Directive and highlight the main changes introduced by the new regulation. Next, I will address the subject of the investigation, the de facto refusal of readmission by the third country. And to illustrate this, I will use a preliminary ruling by the Greek Council of States. And then I will analyze the immediate consequences of this refusal, the risk of the person losing their status as an applicant for connection and all the connected rights. And then finally, I will propose a possible solution pending more far-reaching legislative reform, the application of the requirement of good administration as a legal counterbalance. The concept of safe third countries used along with other terms such as first country of asylum or a safe country of origin to reject applications for international protection. The idea is that if a person has some kind of connection to a country considered safe and does not face serious risks, then they could apply for asylum in that other country rather than in the country where they are now. We need to understand that these three concepts are autonomous. Although attempts have been sometimes made to use one to interpret another, this must be done with caution. We see an example of this later. Then in the Asylum Procedures Directive, Article 31.1, a country can only be considered a safe third country if a series of fundamental principles are met. For example, the applicant's life or freedom is not in danger for reasons such as race, religion, nationality, or political opinion. There is no risk of torture or inhuman treatment. The principle of non-rejection is applied, and there should be a possibility to ask for asylum according to the Convention of Geneva. Then the country has to demonstrate that connection between the national and the country they will be sent to. And then the applicant must challenge the connection or should demonstrate the life endangering situation. The concept of a safe third country has undergone a significant expansion. It is no longer essential for a country to be a party to the Geneva Convention. Now it is sufficient for it to offer what we call effective protection for persons seeking international protection. Secondly, the regulation recognizes valid links with a third country, for example, having family members in that country, which is an advancement versus the directive because it shows what the legislator means when they say connection. And the third relevant change is that the regulation will allow only part of a country's territory to be declared safe. We will see it later. For example, in the Italy-Albania conflicts. In addition, it will allow certain groups of people who may face particular risks within that country to be excluded. This allows for a more nuanced application that is tailored to specific realities. Imagine a transgender person. I don't know to what extent Morocco, for example, could be safe for them. So this reform provides some security for vulnerable groups. Furthermore, when the European Union signs a formal agreement with a third country under Article 218 of the Treaty on the Functioning of the EU, for example, with Turkey, there is a presumption that that country is safe and that no extra analysis is needed. And finally, the new framework provides for the creation of common lists of safe countries at the European level, although each member state retains the possibility of other countries. And then the Greek case is case Z134/23. Presents us with the problem that arises when a country designated as safe does not de facto accept the return of applicants for international protection. The Greek government decided by means of a regulatory act to declare Turkey a safe third country for persons from Syria, Afghanistan, Pakistan, Bangladesh, and Somalia. This decision was based on Article 4 of the EU-Turkey Agreement, in which Turkey undertakes to readmit third country nationals who have transited through its territory before entering a member state. But Turkey has been reneging on this commitment since the start of the COVID pandemic. This is a very complex situation. Applications for international protections are rejected on the basis that the person can be returned to Turkey, but it is known that this return will not happen. And this will remain so. This is a legal and humanitarian paradox that two associations have brought before the Greek Administrative Court. For the plaintiffs, if Turkey has suspended readmission since March 2020, there is no longer any real prospect of these people being returned, and therefore Turkey should not be designated as a safe third country. The judicial authority referring the matter to the Court of Justice of the European Union is the Greek Council of States, which is debating whether the real possibility of return should be made when the concept is applied to the specific person or where the execution of the expel is done. The Council of State had a very divided opinion. They were willing to consider the petitions of the associations that I just mentioned. Well, many things to read here. I just want to help the non-jurists. Article 33.23 allows us to reject a request. First, the fundamental the fundamental principles in that third country, that their life or freedom is not threatened, or grounds such as race, religion, political opinion, there is no risk of serious harm as defined in Directive 2011/95, death penalty, torture, inhuman or degrading treatment, serious threats to life or physical integrity due to armed conflict, no risk of refoulement. They will not be sent to another country where they face persecution or ill treatment, and in that country, they can apply for international protection under the Geneva Convention. Paragraph 2 establishes the national trust must provide for a detailed analysis of whether there is a relationship between the applicant and the third country. In addition, the authorities must be certain that the conditions for applying the concept of safe third country to the specific case are met. That's why the applicants can provide them with arguments. And then paragraph 3 requires that the applicant be adequately informed of the rejection of their application, and that they be given a document in the language of the country of destination explaining that their application has not been examined on its merits. This prevents the third country from applying the concept of first country of asylum, because the article says that the person, paragraph 4 establishes that the applicant cannot be left without a guarantee of real access to protection in another country. If the other country does not reply, we must reply. So from all of the above, the first observation to be made is that Article 38 distinguishes between three situations. On the one hand, the general designation of a country as safe, it is done in a general act. From a doctrinal point of view, it has been argued that Article 31.8, life-threatening situations, etc., brings together the principles applicable to the general designation of a third country as safe. Furthermore, as these are fundamental principles, government cannot limit themselves to a purely formal analysis, but must carry out an up-to-date and practical assessment of the actual situation in that country. This is also found in recital 46 of the directive and the CG-EU in case C 756/21. On the other hand, the specific application of this concept in an individual case, which requires verification that the return is feasible. And then paragraph 4 opens a new avenue because it separates inadmissibility as a legal act from the effective enforcement of that decision. If we focus on the general designation of third countries as safe, the hearing before the CGEU, not in the judgment, implies that an automatic presumption that that country can be designated as a safe third country. The current directive does not establish anything in this regard, and like the new regulation, whose Article 59.7 does introduce this presumption. However, until June 2026, the directive remains in force, and therefore member states are obliged to carry out an individualized country-by-country analysis. The second question was whether, if that third country, in this case Turkey, is not complying with the agreement, should the agreement still be considered valid? Here, the ruling does not give a direct answer, and thank God, because the European Commission was not happy with that pressure. For the Commission, if Turkey is not officially, if Turkey does not officially repudiate the agreement, it continues to have valid legal effects. This makes sense because the agreement goes via the return of applicants, it includes cooperation with Frontex funding for projects in Turkey, etc. Undoubtedly, the real important question was whether, if a real detailed analysis must be made when designating by a general act a country as a safe third country, the plausibility of the readmission should also be analyzed, right? And so we need to review the case law of the European Court of Human Rights, which has been clear. The analysis must be thorough and based on authoritative evidence, like in Ahmed versus Hungary. This means that purely diplomatic reports is not sufficient. According Article 10.b and Recital 48 of the Directive, would be reports from the UNHCR, EASO, the Council of Europe, and other international human rights organizations are the most reliable sources for this analysis. In addition, the nature, duration, and strength of bilateral relations with other country, the existence of mechanisms for monitoring agreements, and effective safeguards should be considered. On the other hand, in the Papashvili versus Belgium case, the ECHR added that this monitoring must be continuous over time and must take into account not only the past situation, but also its future development. So, applicant associations say that Article 38 does not expressly state this, but it seems logical that the real possibility of the applicant being admitted to the third country should be taken into account. Otherwise, the concept itself loses its meaning. In fact, they added their own interpretation of that article. If the background of the applicant's situation must be assessed, it's illogical. For the majority of the Hellenic Council of State, the principle of speed of procedure set out in both Recital 18 and Article 31.2 of the Directive must take precedence. But we can do a different analysis. My friend always says that law is not a science because there is no such thing as an optimal outcome. There is always room for interpretation. And this is one of these cases. We can do a systematic interpretation. In Article 38, we find the concept of safe third country, and then in Article 35, we find the concept of first country of asylum. In the case of safe third country, this assessment of the possibility of readmission should be referred to a later stage. In the other one, it is required the likelihood of readmission be considered from the outset. So here you can see the two articles. I see many differences between them. One of them is very long. So even if the aims are similar, the wording is very different. But they should complement each other if we are to review them thoroughly. So these legal requirements are very different between them. And I don't think we can interpret them in favor of not analyzing them in the general scope. But we can analyze what happens in the new regulation. A little disclaimer here. This doesn't mean that the legislator's intention in drafting the directive coincides with the current one in drafting the regulation, but it gives us a glimpse of the current legislative roadmap. Article 58 of the new regulation removes the requirement to consider potential readmission as a condition, and this is a clear evolution. As a condition ab initio for considering a country as the first country of asylum. With this move, the concept of first country of asylum comes much closer to that of the safe third country, at least from a functional perspective. The Court of Justice of the European Union, in its ruling of this matter, followed the conclusion of the Advocate General that Article 38.4 of the Directive allows for the general designation of a country as safe, even when that country is not actually readmitting applicants, because it considers that other steps will be taken. It is based on the principle of speed. In the General Act, it doesn't need to be taken into account, but it has to be taken into account in this specific case. If it's concluded that there is no reasonable possibility of return, the state country cannot reject the application. And the rulings of the CJEU are sometimes ambiguous. They leave some ambiguity, leaves ample room for interpretation by member states. And this, in a matter as sensitive as international protection, can lead to very different applications in practice. In Greece, the procedure is as follows. The application is rejected, expel ruling is cast, and then they wait for Turkey to accept the asylum seeker. There is no negative administrative silence recognized by Greece. And furthermore, and this is my real concern when I was studying this case, they interpret that once the application is refused, the applicant loses all the rights and the applicant status. So they become an illegal resident in the country. Let's take it step by step. The issue of deadlines. Greece mentioned at the hearing that applicants could request a review of the merits again after a reasonable period of time had elapsed. Reasonable time. What is meant by a reasonable period of time? The state attorney stated that it was 2 months. Why not? We all understand it. It came only after the pressure of many magistrates. Furthermore, according to their interpretation, it will be up to the applicant to initiate a new application without automatically triggering an ex officio review of the merits. So we have no set deadline. We have no recognition of the administrative silence. So is the silence by Turkey considered to be a new element to be considered? So the directive and the regulation state that new elements are those that the applicant has not been able to present previously through no fault of their own, but we don't have a specific date for administrative silence in Greece. Should we take the Turkish rule that establishes a disconnection from the country for anyone who has been outside of the territory for a year? This is significant because in Greece, around 50% of applications submitted by people who transited through Turkey are rejected, and Greece, as soon as it rejects the application, takes away the applicant's rights. The plaintiffs appealed to police sources who indicate that readmission requests are not even sent because it is known that they will not be answered by Turkey. Could a witness statement be used as evidence in the procedure for granting international protection? Law 2619/1991 in Article 7 and following allows its use, but it's not clear under what conditions, whether there is an obligation to tell the truth, what property value is assigned to it, and in fact, it is doubtful that a police officer or civil servant should or would want to testify against the administration itself in an administrative proceeding that is not currently subject to judicial review. This also occurs in Spain. The Common Administrative Procedure Act admits any evidence that is valid in law without further elaboration. There is an obvious problem of proof, and in the end, the regulations mean that we are faced with a diabolical probation where the applicant has no way of reopening the procedure and is left in a situation that we could call refugees in orbit. People whose application has been rejected, who cannot be returned to the so-called safe third country, in this case Turkey, but who cannot also regularize their situation in Greece. This creates a legal limbo, an intermediate space where the procedure is no longer active, but where expulsion has not been possible either. The result is people trapped often for months, if not years, in a situation of uncertainty. This vacuum ends up putting pressure on the applicant who through attrition, ends up voluntarily leaving the territory or is expelled as an irregular foreigner. It is in practice an indirect strategy, because they would be sent to a country where their life could be in danger. But this is a strategy to reduce the number of admissions without having to assess the merits of the applications. And this all happens because European regulations do not expressly clarify whether a decision of inadmissibility automatically entails the loss of applicant status, which is precisely what grants provisional protection and access to basic rights. The Procedures Directive in Article 2.c states that an applicant is someone who has not yet received a final decision. Article 2.e defines a final decision as one that decides on the granting or refusal of refugee status or subsidiary protection. Therefore, in my opinion, a refusal to process an application cannot be considered a final decision. Article 38.4 is clear. If the safe third country does not admit the applicant, the examination of the merits of the application must continue. In other words, the applicant status is maintained. However, in the new regulation, we find a relevant change. Article 3.8 does consider decisions of inadmissibility to be final decisions. And Article 3.13 reiterates that the applicant is the person who has not yet received a final decision.
Personalmente, considero que el artículo
Personally, I believe that Article 3 of the regulation, yes, I became too excited, I get carried away. As I was saying, Article 3 of the regulation is out of line with the rest of the legislation. Article 55.1 of the regulation establishes that any application submitted before a final decision is used must be treated as an additional claim within the procedure. I see an objective of guaranteeing the rights of the interested party by giving them a hearing so that they can rule as in the best possible way. But it is covered in the ordinary basis of the process, Article 11, that establishes that before refusing an application, the asylum seeker should be granted an interview. Article 12 does the same. Before looking at the substance of the situation, the substantive interview. So if there is a guarantee, my interpretation is that Article 55.1 wants to grant a hearing to those individuals out of the procedure. I don't think that makes sense. An applicant, once inadmitted, is out of the circuit because Article 55.1 says that any request must be used as an additional argument.
In the goal is clear. For other country to examine this is wonderful, but if it's not the case, we have to. That someone needs to examine this application. To refuse this means to violate Article 18 of the EU Charter of Fundamental Rights. Of the Charter of Fundamental Rights, which guarantees the right to asylum, and also Article 41, which enshrines the right to good administration. There are different readings and interpretations. Article 43.2 of Directive 2013-32 clearly states that member states may not hold applicants for longer than 4 weeks. In the maximum period is 4 weeks. If no decision has been taken within that time, the applicant must be allowed to enter the territory of the member state, and their application will be processed in accordance with the ordinary procedure. The legislator's intention was to create a framework of guarantees that only allows the use of border procedure if all the conditions and guarantees provided are strictly complied with. Does this 4-week period include the time once a decision of admissibility and return has been taken within that period. Article 2B of the directive regulating the border procedure maintains the definition of applicant that we have already cited. The status of applicant is lost once a final decision has been taken. And of course, if we are not dealing with a border procedure because of the time being, it has been resolved, but an applicant is being held. And if it has been resolved, but an applicant is being held there awaiting expulsion, is this not detention? The Court of Justice judgment issued a joint cases C 924/19 BBU and C 925/19 BBU. It is considered that Article 9 of the directive must be interpreted as not inquiring member states to set a maximum duration for detention in procedures not related to this. The administrative procedure must be conducted expeditiously. This case law is striking. We're talking about a defined and closed perimeter within which movements are restricted and subject to surveillance, from which it is not legally possible to leave voluntarily unless the procedure for granting international protection is waived. In other words, what amounts to a measure of deprivation of liberty. And at least in Spain, maximum guarantees were sought for this period of privation of freedom. The solution that occurred to me is the following: the application of the requirement of good administration. Note something: the term requirement is not used in legislation or case law. The following are normally used as synonyms: right, fundamental right, principle, but there are obviously differences. Therefore, the use of the term requirement, coined by Professor Berta Martin of the Autonomous University of Madrid, seems quite appropriate to me, and I will use it generically until it is time to distinguish between the different terms. Article 41 of the Charter recognizes the fundamental right of every person to have their affairs handled impartially, fairly, and within a reasonable time by the institutions, bodies, and agencies of the Union. In addition, it includes a series of specific rights, like the right to be heard before receiving an unfavorable measure, the right to access the file, and the obligation of administrations to give reasons for their decisions. I repeat, the right of every person to have their affairs handled impartially, fairly, and within a reasonable time by the institutions, bodies, offices, and agencies of the Union. Article 41 literally limits its scope to the institutions, bodies, offices, and agencies of the Union. However, the Charter has its own general regime of application that extends the effects of all rights to national authorities when they apply intra-European law. According to hierarchy of norms, the special provision takes precedence over general provisions. More than anything, it considered that it couldn't leave that as such, because in other cases, like 265/17, formally legally cannot replace the guarantee that an administration will act in good faith, fairly, and reasonably. Therefore, in a line of case law, we can cite, among other cases, C 159/21 and C 62/22. It establishes that the Charter of Fundamental Rights, in accordance with Article 6.5 of the Treaty of the European Union, is primary law in the Union, just like the treaties. If the Charter incorporates and develops the European Convention, expanding its content and protection. Given that the Charter covers much more than the European Convention of Human Rights and that the Convention, in accordance with Article 6.3 of the Court of Justice, is part of the general principles of the law, the Court of Justice seeks to strike a balance between supranational and national competences. To this end, it considers that Article 41 has dual nature, the subjective right, a general principle of law. If we consider Article 41 as a general principle of law, it will apply to all national bodies when they apply to European law. A disclaimer for non-lawyers: a general principle of law is a source of interpretation with substantial value, which can be invoked directly before the administration and the courts without the need for regulatory development. However, it is not in itself, it does in itself not confer an autonomous substantive right that can form the basis of an individual claim. Furthermore, it is a general principle, not a sectorial one, and therefore applies to the entire legal system. What I mean by this is that member states are obliged to respect this general principle of good administration, particularly with regard to impartiality in the conduct of proceedings and the resolution of cases within a reasonable time. We find this in a judgment in last year, January 30th. Now let's apply this to the problem we are analyzing today. In member states, we don't usually find the principle of good administration formulated as such. Rather, we find some sectoral construction of it through specific guarantees. For example, in Law 39, 2015, we find many guarantees, but only for formal procedures. So what happens when there are situations that are outside the administrative procedure? These is legal relationships with the administration that are not formally challenged within an administrative file. In this case, the procedural guarantees included in the aforementioned law that do not apply. However, and this is the key contribution of the Court of Justice case law, if that relationship falls within the scope of the EU law, then the protection of the general principle of good administration is activated, which operates as a supplementary European guarantee to the absence of coverage in national law. Returning to the Greek case, national legislation does not regulate either administrative silence or the maximum time limit for executing an extradition following a decision of inadmissibility. However, with the entry into force of the new regulation, the situation changes. The international protection procedure will be considered closed, and the only thing pending will be the actual implementation of the return of the refoulement. But that phase cannot be left outside the scope of legal control. Although the regulation aims to formally close this procedure, the fact is that an administrative relationship of enforcement persists, and that relationship imposes on the administration a continual obligation to respect union law, to act fairly, impartially, and within reasonable time. And the process cannot be prolonged forever. I am therefore of the opinion that in the absence of a response, an applicant may invoke the interpretation of the term new element. Let's move to the conclusions. There are 7 conclusions to sum up. First, the possible likelihood of readmission to the third country is not an obstacle to designating it as a safe third country in an act of general scope. Second, this analysis must be carried out where appropriate when assessing the particular case to which the concept of safe third country is applied. Third, on June 12, 2026, agreements with third countries gives rise to a rebuttable presumption in favor of their consideration as a safe third country. Fourth, without a formal response or deadlines limiting the waiting time, the regulation as such do not allow for the granting procedure to be reopened. This status of the applicant puts us in a problematic situation, and the directive would allow for a favorable interpretation, but the regulation does not allow it. 6, given that a final decision can be considered to have been taken, the 4-week guarantee in relation to the border procedure appears to be diluted, and consequently, the applicant's situation could resemble detention with deprivation of liberty. And 7th, in the absence of specific regulations, the general principle of good administration, by going beyond limits of the administrative procedure and covering all relations with all the administrations, could emerge as a source and interpretative limit of the terms new elements, applicants, and other similar terms, protecting guarantees not provided for in domestic law. I remain at the disposal of the public and the panel of experts for any comments or questions that may arise. Thank you very much.
Muchas gracias.
Thank you very much, Mr. Fornaris, for this presentation of this so complex topic. I will make a few comments and remarks, and then I will give the floor to the audience. I have a formal comment. taken that this is part of a publication and there are still a few months to publish it, I would include in the title regulation, because by then the regulation will be in force. You can refer to the directive, but I think you should mention the regulation too, so that everyone is aware that you will consider it just by looking at the title. And the other aspect that is more deep is about taking into consideration as an interpretative criteria, because the following interpretations are really good, but I miss the connection with the basis of the treaties, the European Union treaties, since the moment the Amsterdam Treaty is published, and then we have Article 78 of the Treaty of the Functioning of the European Union that leads to the Geneva Convention and the Statute of Refugees. There you can find general categories that can come in hand when it comes to reinforce your criticism to the development of the derivative law. And this takes me to two figures that arise from here. One is the possibility of subsidiary protection, because once asylum is out of question, subsidiary protection may be an option. How could we reinforce this guarantee for the applicant? If this application is refused, maybe they can get a subsidiary protection. And then on the other hand, we have the connection with a fact, which is the refoulements in the borders. This is very problematic. It does not allow for individual analysis. In these cases, when there are massive refoulements, like for example, 50 people, there is no individual analysis of each of the cases to see whether asylum would apply. Then we have different instruments. And then in this legal grounding that I would use as an introduction without elaborating on it, then we have a concept that you used later on. There's a value that arises from Article 6 of the treaty, that gives a legal value to the Human Rights Convention and the obligations that are common to all member states. This connection may serve you to connect to the judgment of the European Court of Human Rights that would help us to pose this criticism to this concept of safe third country. Then that is pretty tricky, as we know, because seeing what happened with the European Pact on Migration and Asylum in June, a few weeks ago. This was very recent. 25, yeah, it was June 2025. There, they include Morocco, India, Bangladesh, Egypt, Kosovo, among others, safe countries. Oh my God, safe countries. It includes the caveat that if there are individual cases where it is made clear that the person may be at risk, but this list, if they start taking it seriously, this is very problematic. And this is a cause of concern, because it is obvious that people who set foot in a European country, everyone seeks for asylum automatically. It is the instruction that they receive, regardless of what their circumstances. And that needs to be checked. But you can't take it for granted that everyone has a right to asylum, but you cannot think that everyone that receives a refusal has receive that refusal in a right way, with grounded reasons. Regarding the development of your research, you connect everything very well because there's an administrative judgment to the right to good administration. But if you connect this with the Charter of Fundamental Rights and the judgment of the Court of Human Rights, you have to consider that the Charter allows that right to everyone in the territory, the right to judicial protection, an effective judicial protection. There cannot be autonomous decisions in the framework of the European Union. So the role of this effective judicial protection must be reinforced. Article 41 of the Charter considers this, because if we review the characteristics of the good administration that provides rights in that time, it's practically a copy of the guarantees of the equitative right. It is an implementation of the guarantees that must be in place. So since this judicial revision must happen, I would put a focus on the right to effective judicial protection, which is common to member states and is part of the European Convention of Human Rights. That could reinforce some of the aspects that you propose that are very rightly expressed, but that maybe should be reinforced a little bit. Okay, so let's give the floor to the audience.
Hi. Thank you very much for this very extensive presentation. I have a question and actually a small remark. I live in the southern Italy, so every week we have people coming on boats. Italy, as you know, because you're affiliated with the University of Bologna, has been quite central in this debate. And especially in the last couple of months, there has been a major scandal in Italy because the Italian government is using detention centers in Albania. So the big question was, and continues to be, the right of Italy actually to pay for these services in Albania, where potential asylum seekers are being held. So this brings me to what you mentioned in your presentation in Spanish, but I would translate it as margins of interpretation. Margini di interpretazione, but it sounds similar in Spanish. Yeah. So isn't this actually quite central, I think, for your paper, for your discussion, these kind of workarounds that exist, like the third country? Instead of engaging with the right of asylum seekers in the country itself. So there is another workaround, the legal workaround. And I'm saying this because it resonates with other types of legal workarounds. For instance, in Italian constitution, Italy is prohibited of going into war. But then we find a legal workaround to participate in the war. So isn't this kind of like a legal workaround on the margin of interpretation? And secondly, what I would like to see maybe in your paper is this maybe a more humane kind of an humanistic understanding about what we are actually dealing with. So these kind of legal frameworks are easy to be lost in. So maybe you should really assess the situation of who are the asylum seekers. You use a couple of pictures, that's really nice, but let's not forget that we are talking about real people with real needs and real problems. Thank you.
May I even go a bit further? With regard to the current situation, the migration issue within the European Union, which really fosters right-wing and also left-wing populism, which may become a threat to the existence of the European Union. I'm painting black now, I know. Wouldn't it be necessary to put the whole asylum law to a test and maybe even change it completely in order to safeguard the external borders of the European Union and to lower the pressure on the politics of the nation states? It's provocative, I know, but I mean, we are here to think about certain ways out of crises.
Bueno,
Thank you very much, obviously, because there are some elements that I hadn't considered. I take note of your suggestions. Regarding your question about border protection, I am not saying that we should accept everyone who comes in. That is obvious, but I do believe that we must safeguard and respect all the guarantees that we keep talking about. We keep talking about European values, Article 2, and there are cases against member states because of these values. There are lawsuits internally. For example, people from Greece have their own guarantees, but once someone enters our territories, I think we should defend those guarantees. If the application of the concept of safe third country wants to be reinforced, it's okay, but guarantees must be protected. I understand what they're doing in Greece, but however, there is a margin. We're talking about margins, but I think that margin is dangerous. My work is totally different. I work in the economic law, and my colleagues always say that I always protect rights, but we always have to respect constitutional rights because we don't worry until they affect our own constitutional rights, and it's only when it comes to others that we have to think that what affects others may affect us at one point. Yes, on paper, everything sounds good, but we have to take into consideration the practical situations. However, I think that constitutional rights are to be protected. They're there for a reason, they're there to be protected. I am going to make a question in connection to what TERESA Freixes was saying in the beginning. It is good to consider and approach this topic from the point of view of the directive. You made a great effort and you explained it very well. However, once again, I see that if you consider the last 75 years of the European Union, you will see that there has been a set of regulations in place, regulations or mechanisms to seek for solutions for asylum and migration. Did you go over the Dublin regulations 1 to 3, the SECA, that is what shifted the Dublin regulations, because what SECA proposes is to have a European asylum system. And it proposes to harmonize the asylum seeking systems and the protection systems. But there are differences between member states when it comes to the material conditions for welcoming. So the SICA did not perform very well. And if we go to the Migration and Asylum Pact or Convention, in 2024, I'm not talking about 2025, it tries to respond. I think Jürgen is right when he says that maybe the system needs to be reviewed, because the asylum system is not going to work structurally because we are organizing it legally without considering the social reality. So my question is, the Migration and Asylum Pact, I think, reinforces the security approach, security above all, and it prioritizes the administrative efficiency, as you were saying. But border control must involve human rights protection. And where are those protections? What have we done to move forward? The three directives, the Dublin regulations, the SECA, and the Migration and Asylum Pact tell us that the logic should involve containing and outsourcing the problems. That is the logic. And we keep looking for solutions, beating around the bush, and we are not getting the problem right. And maybe, although the 2024 Pact introduces several technical advances, there's no structural disconnection with the excluding dynamics that have characterized the European asylum policy since its origins. This is a failure that we keep uh, uh, dragging, and we need to look for the legal way to work it out, but we're not doing it right. Thank you. Many years ago, when I did my master's final work, I did my final work on the treaties that you mentioned first, and I'm empathic with reinforcing security. We saw what happened in Paris with the celebration of, I don't know what soccer game it was. There are serious security problems. This is real. I don't want to say, and I don't want to say that I must destroy the system because it's being recorded, because it doesn't work. I don't want to say we should destroy the system because it's not working. There are failures, serious failings in the work that I did, my master's work. I did that there. I realized how there were failings. There was a news not that long ago stating that Germany was the country that received the highest number of applications. I think in my work, I won't have time to decide whether or not I destroy the system. I think a doctorate thesis doesn't have the capacity to address all this. However, I must say that in Luxembourg, sometimes we see things from a bubble. We live in a wonderful bubble. Everything is wonderful. We should open the door to everyone. We should all be happy. And we forget about the impact that this has. Judgments often are very abstract, and they don't take into consideration the effects. We not only see this here, we see this on many fields. I will take into consideration what you're saying. The right of member states to pay for the outsourcing of detention centers, border protection. This is something that I need to take into consideration in my work to make this article more realistic. Good morning, and thank you very much, Ignacio. Thank you, Professor Freixes. The topic that you addressed is very interesting. However, this is a very complex topic. Let me tell you that it's very complex. There is a whole set of regulations. Just trying to interpret the regulation is being challenging. So this regulation analysis that you do is very interesting. However, I am missing, as Anna was saying, I am missing a more humane perspective, because we are talking about people. As Professor Teresa was saying, we need to think about individual cases. In that context, yes, of course, we have regulations, we have legal instruments. There are legal instruments that you left on the sides, and we have to analyze the judgments of the Court of Justice. of the EU. So, I mean, you introduced so many things. You talked about vulnerable groups, for example. And I think here there's a judgment of October 2024 on Afghan women that judgment is maybe not a milestone, but at least we should say that it's a very important work that the Court of Justice did to provide asylum protection to women who come from Afghanistan. All countries are obliged to host these women who are being the victims of the Taliban just because they're women. For the mere fact of being women, their lives are endangered. That I mean, we should congratulate the Court of Justice, but this leads us to what the professor was saying. Should we open the doors to everyone? What do we do? What happens to the rights that these people claim when they come to this territory? They get a residence permit, they get some support. What does involve for the state? How are we doing economically? In Spain, we are not in a situation where, I mean, it's not the best situation of abundance. Our situation is quite delicate at this time. Thank you. In my in my study, I talked about the protection in the embassies, and because of the crisis in Damascus, my conclusion was that the protection in embassies is really complicated. I am aware and I'm worried about the economic impact, and I'm concerned about it more in terms of populism, because we know how the world is working and what the elections are telling us. In Galicia, we saw what happened when official housing was allocated to some people, and we know that this is a very hot topic. I have mixed feelings when it comes to this topic, because I am in favor of protecting people, because if something happened in Spain, I would like someone to give me a hand, because I like to put myself in the situation of others. But there is a big pressure against migration. There's a strong movement. I take note of everything that you're saying, but that's why I try to work in an abstract way. I talk about this 50% of people in Greece who are going through Turkey. I don't really know how to fit this in the large perspective. If I knew how to solve this, maybe I would be making more money than writing a PhD thesis, honestly. So, well, thank you very much. We have another question here from the back of the room. Good afternoon. First, thank you very much, Ignacio, for your presentation. From a legal perspective, it was amazing. You helped me very much because my presentation is the next one, and you set the pace. My name is Gloria. I found that you use a term that is very interesting, refugees in orbit. I had never heard it. Is it your own concept? Where did you get this concept from? Did you coin that term? Refugees in orbit. And how does this connect with the concept of irregular refugees or illegal refugees? In my vision, you should never use the term illegal. I think we should use the term undocumented, as some authors do. Well, I'm just curious about that term.
Thank you. Well, it's a term coined by one of the lawyers of the associations I mentioned. for asylum seekers in Greece. But then I was sent an email in Greek that I translated using an automatic translator. I think I got the right term, but well, it really describes people living in a limbo, in a legal limbo. When I started out studying all these, I wanted to showcase the problem and how the European Court solved it. And then I found that the asylum seekers were left without a protection framework. And I thought, oh, they got carried away. This got out of their hands. But going back to your question, I don't know. I just heard it. I thought it was very descriptive. And well, I don't know, maybe people coined it. But I liked it anyway. That's why I used it. Any more interventions? Professor Freixes, any more final remarks? Yeah, well, I want to close this session by saying that in all the legislative procedure of the derived law, there were many problems because there was this resistance, this reluctance of the European Union to regulate. They considered the policy. I was working on that very subject matter with them in some countries, in Tunis, for example, and they had to redress the question because they wanted to always look at it through the lens of the politics and policies. The human thing did not really have any weight. So yes, we need to put an accurate framework on things in an objective way. And then who will apply the law? The border officer will not pay attention to Article 6 of the Convention or the third. No, they're given a protocol and that's it. So we need to add something else. What type of protocols would be implementing all these articles of the regulation? Because that will be practical application of things. They won't be reading the regulation. They will not be interpreting the rulings by the European Court of Justice. So that is something to be taken into account, since that is precisely when the person enters the country and asks for asylum, and they will get a temporary reply that will condition the whole process, the whole subsequent process. Okay, so that was an excellent presentation. Congratulations, an excellent discussion. We know it is a very complex topics, and we've made our. You have to do your best to try and condensate everything in your final work. Thank you, dear audience. Thank you, Teresa Freixes. We have a 5-minute break, but first a round of applause.